Good afternoon. My name is Justice, and I'll be discussing the Loper Bright Enterprises versus Raimondo case. This case I'll be discussing further as the Loper case, that's how I'm going to reference it, and this case is concerning the doctrine of Chevron deference. We'll discuss that doctrine further in just a moment, but to give you the facts of the case, this case is about a group of North Atlantic fishermen who are unhappy with the National Marine Fisheries Service's interpretation of the Magnuson-Stevenson's Fishery Conservation and Management Act of 1976, which I'll be referring to as the Magnuson-Stevenson Act. Now, the National Marine Fisheries Service interpreted this act as allowing them, as a reasonable precaution, to charge the fishermen $710 a day so that they can have an at-sea monitor on the boat. That way they can make sure they're following all guides and regulations. This was not an expressly permitted option to the fisheries service. It was not something expressly permitted within the statute. It is something they decided was reasonable under the statute, under the service's own interpretation. What this case was concerning was, can an administrative agency such as the National Fisheries Marine Service interpret a statute in that way, or is it up to a court to make that decision? The doctrine of Chevron deference was established in a Chevron case prior to this, and what that doctrine allowed was that when a statute has vague or ambiguous language, such as saying you must follow a reasonable guideline, it is up to the courts to follow the most applicable administrative agency's reasonable interpretation. That is to say, the courts cannot come up with a decision themselves. They must follow the binding authority of a local administrative agency, even if it goes against what the courts themselves would interpret the statute as saying. The doctrine of Chevron deference was overturned in the Loper case. The court ruled in favor of the Supreme Court ruled in favor of the fishermen themselves, and that the doctrine of Chevron deference did not give the administrative agency the power to make this decision. The question today is Chevron deference a doctrine that should be upheld or should have been overturned? And was the court correct in overturning Chevron deference in the Loper Bright case? I would like to discuss the question over whether Chevron deference is an applicable and useful doctrine to the court through the view of Richard Dworkin's first in his writing on constitutional cases. In Dworkin's writing on constitutional cases, he argues for the constitutional concepts to be interpreted through modern viewpoints. That what is cruel and unusual then might not be cruel and unusual now, and what was not cruel and unusual back when the framers wrote the Constitution may be considered cruel and unusual through the Constitution now based on our modern set of morals, and that we should adhere to those based on the concepts the Constitution laid out. He also argued that this sort of interpretation should not be beholden to the democratic process itself, as the point of the rights and the protections provided by the Constitution is to protect the minority from the majority. That those in power and that those hold the power of the democratic process, the largest group of people, should not have the right to do as they wish with the nation, that the Constitution is a protection against this. And therefore, the interpretation should usually be done by groups not beholden to that democratic process as strictly. With that being said, I believe Richard Dworkin would favor the overturning of Chevron deference for two reasons. Number one is that it goes against his initial view that we should view the constitutional concepts in a modern lens. The overturning of Chevron deference was argued based on the ideas of the framers, yes. However, the doctrine of Chevron deference was not built off of the interpretation of the Constitution, but rather it was an alteration of how the separation of powers is constructed. It was giving a power given by the Constitution to the courts over to administrative agencies from the executive branch, rather than leaving them in the hands of the courts. It went further than the permitted changes that Richard Dworkin's discussed. Now, beyond that, it also gave the power of interpretation to a group beholden, admittedly not directly, to the democratic process. The people selected to run the administrative agencies, the people who operated them, are usually chosen by an elected official. A group which is more forced to adhere to the democratic process and the opinions of the public rather than being told to adhere to the document itself. Now, when interpreting the statutes, the administrative agencies are the ones with specialized knowledge on those statutes. They're the ones who have scientific knowledge of the environment, who are used to working with things such as workplace regulations, and when laws are written to bear over these things, these are groups that have the specialized knowledge to it, while they may not have knowledge of the law itself. Richard Dworkin's was very much pro-evolution, pro-living document for the Constitution. He wanted it to change as society changed. But I believe the change we see here is one that goes beyond what his argument at least entails at this point. He may support it in a different form if it still kept the power in the courts. He may support the general idea of giving a group with specialized knowledge the power to interpret rather than leaving it in the hands of judges who do not have specialized knowledge on certain concepts. However, he would want to see that power stay in the courts, I believe, and the courts alone, which is what overturning Chevron deference did. That is how I believe Richard Dworkin would view it. However, there's another pair of authors who wrote a similar document that I think would have a different conclusion. After discussing Richard Dworkin's, I'd like to talk about Munzer and Nickel. Their view is that the Constitution itself is a both written and unwritten document which can be altered through the interpretation by authoritative figures. They view the Constitution as not only a living document, but a document which can be altered in the most fundamental manners, through interpretation and through how that is affected. I believe they would see the doctrine of Chevron deference as permissible, something which is allowed because it was interpreted by an administrative agency to be allowed, because that's the way our government wants to work now. They would see the doctrine of Chevron deference as giving the power of interpretation on certain statutes to those best well-equipped to interpret those statutes through their knowledge of those specific areas of law and of science and technology. Those who know about the environment interpret statutes concerning the environment. Those who know about workplace regulations interpret statutes concerning those. Munzer and Nickel discussed how the Constitution cannot be only interpreted through the ideas of the framers and through their intent. How modern legislative intent and legislative viewpoints should be included there through authoritative figures' interpretation of the document. I believe they would see this as a modern evolution of the Constitution in a healthy manner which aids the nation, and that they would support the doctrine of Chevron deference in maintaining it. They would not want it overturned as it was in the Loper case, and they would be against that decision. My personal viewpoint on the doctrine of Chevron deference is that it is a step in the right direction, and that Loper made a mistake in overturning it. I believe that Chevron deference gives the power of interpretation to those who are best and most well-equipped to interpret on certain scientific statutes, on ones that require that specialized scientific knowledge. When you have a judge who has no experience in a certain area, the power to interpret how a law in that area should be enacted, they're not going to have the best or most technical or most exact opinion. There's going to be blind spots, there's going to be errors in their knowledge, and there's going to be things they simply do not know. Now, this is supposed to come out in trial litigation, where there should be arguments over, is this law, is this doctrine viable, is this law, the way it's affected, good for and healthy for the nation, is this how Congress intended it to be enacted? But those don't cover all the bases. Those don't give the judge a background of knowledge that they might need years, that they might take years for them to obtain. Those leave a lot of blind spots for judges who just simply do not or could not know because they didn't get a degree in a specific field, and they would be lost on how to interpret it. Their degree is in law, not in environmental policy, not in workplace safety regulations, or in anything of that sort. With that being said, the doctrine of Chevron deference may go too far by requiring courts to follow administrative agencies' interpretations unless they're unreasonable. The one defense that courts have against an unreasonable or ill-equipped interpretation from an administrative agency is that clause that the interpretation must be reasonable. But that clause is not 100% foolproof. That clause leaves room for judges who do not know if something's unreasonable because they do not have that knowledge, or if an interpretation is reasonable but goes against the intent of Congress, or if an interpretation is reasonable in the view of the judge and in the view of the agency, but not in the view of anyone else. If there's people who disagree on if a doctrine is reasonable or not, a judge may not be the best or most well-equipped to interpret that. So I support Chevron deference as a concept. I think it is an effective way to enact and specify how certain legislation should be viewed, but there may be flaws in how it is affected and that there could be a better way to write it. Perhaps having administrative agencies have not binding but persuasive authority, or giving the administrative agencies some sort of oversight group for how these statutes are interpreted themselves. When it comes down to it, the power of interpretation lies in the courts alone, as per the Constitution. But when we allow that to change and evolve with the modern government and how it views how things should be enacted, we can see better forms of government evolved from that. And sometimes the Constitution, when it changes in these manners, it changes to benefit the people. Chevron deference is one way in which the balance of powers has been altered since the founding of our nation. And with its overturning, we see the powers return to how they used to be. And we will see if the courts can interpret these statutes effectively. But until we see that, I will be in support of the doctrine of Chevron deference staying and being maintained, even if it goes against the direct instructions of the Constitution in the separation of powers.